The case management system showed I had conducted 3 client consultations yesterday while I was in court defending a negligent security claim. My name is Benjamin Pinehurst, 42 years old, Attorney Development Director at one of Detroit's most prestigious partnerships. I specialize in premises liability and personal injury law. 20 years of practice had taught me to trust data over instinct, but the timestamp discrepancies staring back at me from my monitor defied logic. I scrolled through the digital logs again. 3 separate entries. Catherine Jefferson, my secretary of 8 years, had scheduled the meetings. Each consultation lasted exactly 90 minutes. Each client had signed retainer agreements. Each file showed my electronic signature authorizing representation. The problem was simple. I had been cross-examining a security expert at the Wayne County Circuit Court from 9 a.m. until 4 p.m. yesterday. Court records would confirm my presence. The bailiff knew me by name. I pulled up the billing software. 3 new client accounts, substantial retainer deposits, all processed through our standard payment portal. The amounts were significant enough to trigger automatic partner notifications, yet none had reached my inbox. My coffee grew cold as I dug deeper into the system. The consultation notes were detailed, professional, written in my typical format. They referenced case law I frequently cited. The legal analysis matched my methodology perfectly. Someone had studied my work extensively. I checked the security camera logs for our conference rooms. The footage showed me conducting all 3 meetings. Same suit I had worn to court. Same mannerisms. Same legal pad positioning. The timestamp matched the billing records exactly. But I had never seen these clients before in my life. The retainer agreements bore my signature, not a forgery. The pressure points and pen flow looked authentic under magnification. The handwriting analysis software confirmed a 97% match to my verified samples. I called Catherine's extension. No answer. Her desk sat empty, computer locked, coffee mug still warm. She had mentioned a dentist appointment during lunch, but that was 3 hours ago. The client files contained detailed intake forms, personal information, financial statements, medical records for potential malpractice claims, sensitive documents that required careful handling and strict confidentiality protocols. Someone had accessed my digital signature certificate. Someone had used my identity to establish attorney-client relationships without my knowledge. Someone had collected substantial fees in my name while I sat in a courtroom 12 miles away. I printed the consultation records and locked them in my desk drawer. The partners would demand explanations I could not provide. The state bar would investigate unauthorized practice allegations. These clients would expect legal representation I had never agreed to deliver. My hands trembled slightly as I reached for my phone to call building security. The investigation began 3 weeks earlier when Catherine Jefferson first approached me about streamlining our client intake process. She had worked as my secretary for 18 months, handling scheduling and document preparation with meticulous attention to detail. Her suggestion seemed logical. Automate consultation bookings through our case management system to reduce administrative overhead. Mr. Pinehurst, I've been reviewing our efficiency metrics, she said, standing in my doorway with a tablet in hand. We're losing potential clients due to scheduling delays. I could set up direct booking links that sync with your calendar automatically. I had been drowning in depositions for a complex commercial litigation matter. The partnership was pushing all senior associates to increase billable hours while maintaining client satisfaction scores. Catherine's proposal offered a solution to both problems. What would you need from me? I asked, barely looking up from the discovery documents spread across my desk. Just your digital signature authorization and calendar access. I'll handle the technical setup and client communications. You'll receive automated summaries before each meeting. The trust came naturally. Catherine had proven herself reliable during high-pressure cases. She stayed late when deadlines loomed. She caught errors and pleadings before they reached opposing counsel. She organized my files with surgical precision. I granted her the requested system permissions that afternoon. The first warning sign appeared 2 weeks later during a partner meeting. Malcolm Jefferson, our managing partner, mentioned an uptick in consultation requests from personal injury prospects. Benjamin's been pulling in quality leads, he noted. 3 new retainers this month from motor vehicle accidents. I nodded politely, assuming he meant referrals from existing clients. Personal injury work represented a small portion of my practice, but the firm encouraged diversification. The comments seemed unremarkable at the time. The second red flag emerged when I reviewed my monthly billing summary. The consultation fees showed a 23% increase over the previous quarter. The system attributed this growth to enhanced client acquisition protocols implemented by my administrative team. Catherine had mentioned optimizing our intake procedures, but I had not realized the extent of her initiatives. When I asked for details, she provided a comprehensive report showing improved conversion rates and reduced scheduling conflicts. The automated system is working perfectly, she explained. Clients appreciate the immediate response times. Your consultation calendar stays full without constant manual adjustments. The documentation looked professional. The metrics supported her claims. The increased revenue pleased the partnership. I had no reason to question her methods. The third anomaly surfaced during a casual conversation with our IT director. He mentioned upgrading security protocols for digital signature certificates after detecting unusual access patterns in the system logs. Someone's been using signature authentication outside normal business hours, he said. Probably just weekend work, but we're implementing additional verification steps. I rarely worked weekends at the office. My signature certificate should have shown minimal after-hours activity. When I requested the access logs, the IT director promised to compile a report but never followed up. The investigation accelerated when I discovered the consultation records in our billing database. The 3 mystery clients had paid substantial retainer fees for legal services I had never provided. The meeting notes contained intimate details about their cases, details that required face-to-face discussions and careful documentation. I pulled the security footage from our conference rooms. The recordings showed me conducting professional consultations with unfamiliar clients. My body language appeared natural. My legal analysis sounded competent. The interactions looked completely authentic. But I had been in court during each recorded session. The timestamps proved impossible to reconcile. Court records showed my presence at hearings during the exact times these consultations occurred. The electronic filing system logged my document submissions from the courthouse. My parking garage keycard registered my vehicle's departure and return. I could not have been in 2 places simultaneously. The signature analysis revealed the most disturbing. Every retainer agreement bore my authentic signature, not a digital reproduction or traced forgery, but actual ink from my pen. The pressure patterns matched my natural writing style. The letter formations showed consistent characteristics with verified samples. Someone had obtained my physical signature on legal documents without my knowledge. I confronted Catherine directly. She sat across from my desk, maintaining steady eye contact while I explained the discrepancies. Her expression remained calm, professional, slightly concerned. That's very strange, Mr. Pinehurst. I scheduled those consultations according to your calendar availability. The client seemed satisfied with your representation. I was never here for these meetings. The security footage shows otherwise. Perhaps you're experiencing some memory issues? The stress from the Morrison case has been intense. Her suggestion felt like a calculated deflection. The Morrison litigation had indeed consumed significant mental energy, but I maintained detailed calendar records and case notes. My memory remained sharp for all other professional activities. Show me the original scheduling requests, I demanded. Catherine accessed her computer and displayed the booking confirmations. The timestamps showed consultation requests submitted during evening hours when the office was closed. The client contact information included phone numbers that went directly to voicemail when I called them. I'll need copies of all communications with these clients. Of course. I'll compile everything and send it to your secure folder. That evening, I received a comprehensive file containing consultation transcripts, client intake forms, and follow-up correspondence. The documents painted a picture of thorough legal representation spanning several weeks. The writing style matched my professional voice perfectly. But I had never written any of these documents. The breakthrough came when I examined the metadata embedded in the digital files. The creation timestamps showed document generation during hours when I was attending continuing education seminars in Chicago. The IP address logs revealed access from my office computer while I was physically present at the state bar conference. Catherine had been impersonating me for months. She had used my digital signature to establish attorney-client relationships. She had collected retainer fees in my name. She had conducted legal consultations while posing as a licensed attorney. The scope of her deception became clear when I discovered additional consultation records buried in archived billing folders, 12 separate clients over 6 months, nearly $40,000 in unauthorized fees, detailed case files documenting legal advice she was not qualified to provide. She had studied my consultation techniques, memorized my legal analysis patterns, and replicated my professional demeanor with disturbing accuracy. The security footage showed her wearing similar business attire and adopting my mannerisms during client meetings. Catherine Jefferson had stolen my professional identity and used it to practice law without a license. The confrontation required careful planning. I scheduled a meeting with Catherine for the following Monday morning, requesting she arrive 30 minutes before the office opened. I positioned recording equipment in the conference room and prepared printed copies of the U-Tream. Catherine entered wearing her usual professional attire, carrying a leather portfolio and coffee. She settled into her chair with the same composed demeanor she had maintained throughout our working relationship. I need to discuss some irregularities in our client billing system. I placed the consultation records on the table between us. Her eyes moved across the documents without visible reaction. The silence stretched for nearly a minute. These appear to be standard intake forms. Standard forms for clients I never met, consultations I never conducted, retainer fees I never authorized. Catherine's expression remained neutral, but her hands stopped moving. The portfolio remained closed on her lap. I'm not sure what you're suggesting. I activated the laptop and displayed the security footage, showing her conducting meetings in my office. The timestamp clearly indicated my absence from the building. Her image on the screen showed her gesturing with the same hand movements I used during client presentations. The metadata shows document creation during the Chicago seminar. The IP logs confirm computer access while I was at the state bar conference. The bank deposits match the consultation fees exactly. Catherine watched the footage without comment. When it concluded, she closed the laptop screen and leaned back in her chair. You have an interesting theory. I have documented of unauthorized practice of law. $40,000 in fraudulent billing. 6 months of identity theft. The recording equipment captured every word as Catherine finally acknowledged the scope of her deception. She described studying my legal techniques through observation and document review. She explained how she had memorized my consultation scripts and practiced my professional mannerisms. The clients believed they were receiving legal representation from a licensed attorney. Catherine had provided detailed legal advice on contract disputes, employment issues, and business formation matters. She had drafted legal documents using my digital signature and letterhead. The clients received competent representation. You're not licensed to practice law. Every consultation constituted criminal fraud. Catherine's composure finally cracked. She admitted to creating the elaborate deception because she believed her legal knowledge exceeded that of many licensed attorneys. The unauthorized fees had funded her law school applications and LSAT preparation courses. I terminated the meeting and immediately contacted the Attorney Accountability Commission. Investigator Henry Patel arrived within 2 hours to begin the formal investigation. He reviewed the files and interviewed Catherine under oath. The Commission's investigation revealed additional violations beyond unauthorized practice. Catherine had accessed confidential client files from other attorneys in the firm. She had copied privileged communications and stored them on personal devices. The security breach extended to cases involving corporate mergers and criminal defense matters. The partnership convened an emergency meeting that afternoon. Managing partner Malcolm Jefferson reviewed and authorized immediate termination of Catherine's employment. The firm's malpractice insurance carrier was notified of potential claims exposure. Criminal charges were filed within the week. The prosecutor's office pursued felony counts of identity theft, wire fraud, and unauthorized practice of law. Catherine's bail was set at $50,000 pending trial. The affected clients required individual notification and case review. Several had relied on Catherine's unauthorized legal advice for significant business decisions. 2 clients filed malpractice claims against the firm despite never having established legitimate attorney-client relationships. Malcolm Jefferson implemented comprehensive security protocols to prevent similar breaches. All client consultations now required dual authentication. Digital signatures were restricted to licensed attorneys only. Security cameras were installed in every conference room and office space. The State Bar Association launched its own investigation into the firm's supervision practices. They questioned whether adequate oversight could have prevented Catherine's deception. The partnership faced potential sanctions for failing to detect the unauthorized practice occurring within their offices. Catherine's trial began 3 months later. The prosecution presented overwhelming of systematic fraud and identity theft. Her defense attorney argued that no clients had suffered financial harm from her legal advice. The jury deliberated for 6 hours before returning guilty verdicts on all counts. Catherine received a sentence of 18 months in state prison, followed by 2 years of supervised probation. She was ordered to pay full restitution to the affected clients and the law firm. The conviction triggered automatic disbarment proceedings despite Catherine never having been admitted to practice law. The State Bar Association wanted to ensure she could never apply for licensure in any jurisdiction. I testified at both the criminal trial and the bar disciplinary hearing. The experience of describing Catherine's deception in open court provided a sense of professional vindication. Justice was being served through the legal system I had dedicated my career to supporting. The firm's reputation recovered gradually as news of the conviction spread through the legal community. Other attorneys shared similar stories of employee misconduct and security breaches. My experience became a cautionary tale about the importance of internal oversight and verification procedures. 6 months after Catherine's sentencing, I received a call from an attorney in Grand Rapids facing a similar situation. His paralegal had been conducting unauthorized client intake meetings and collecting consultation fees. I shared my investigation techniques and collection methods. The legal community's response reinforced my belief in the profession's capacity for self-correction and accountability. 12 months later, I stood in my new office overlooking the Detroit River. The nameplate on my desk read Benjamin Pinehurst, Managing Partner, at a boutique litigation firm specializing in professional liability defense. The transition from corporate law had been surprisingly smooth. My new practice focused exclusively on representing attorneys facing disciplinary actions and malpractice claims. The Catherine Jefferson case had given me unique insights into how professional misconduct investigations unfold. Other lawyers sought my expertise when facing similar crises. The firm I left behind had implemented comprehensive security protocols following the investigation. All client meetings now required advanced scheduling through a centralized system. Video monitoring covered every conference room. Employee access to case management systems was restricted based on specific role requirements. Malcolm Jefferson, my former colleague who had helped expose Catherine's scheme, joined my new firm as a senior associate. His analytical skills and attention to detail made him invaluable in defending complex professional liability cases. We had developed an effective partnership built on mutual trust and shared experience. The Attorney Accountability Commission had used our case as a model for investigating similar misconduct allegations. Henry Patel, the account recovery investigator, frequently referenced our documentation methods in training seminars for other investigators. The systematic approach we had developed became standard protocol. I launched a newsletter exposing partnership abuses nationwide. The monthly publication reached over 3,000 attorneys across Michigan and neighboring states. Each issue featured case studies of professional misconduct, prevention strategies, and regulatory updates. The response from the legal community exceeded my expectations. Catherine's conviction had created ripple effects throughout the Detroit legal market. Law firms began conducting more thorough background checks on support staff. Professional liability insurance carriers started requiring enhanced internal controls as policy conditions. The changes represented meaningful progress in protecting both attorneys and clients. My new practice handled 17 similar cases in the first year. Each situation involved trusted employees who had exploited their access to commit fraud or unauthorized practice. The patterns were remarkably consistent across different firm sizes and practice areas. The work provided professional satisfaction that had been missing during my corporate law years. Helping attorneys navigate disciplinary proceedings and rebuild their practices felt more meaningful than drafting merger agreements. The personal stakes were higher, and the outcomes more directly impacted individual lives and careers. Catherine had been released from prison after serving 14 months of her sentence. She moved to another state and found employment in retail management. The conviction would follow her permanently, but she had served her time and paid restitution to all affected parties. The clients who had received her unauthorized legal advice had suffered no lasting harm. Most cases were resolved successfully by qualified attorneys who took over their matters. The firm's malpractice insurance covered any additional costs incurred during the transition. My reputation in the legal community had been enhanced rather than damaged by the experience. Other attorneys respected how I had handled the investigation and prosecution. The methodical approach and commitment to transparency had demonstrated professional integrity under pressure. The new office felt like home in a way the corporate environment never had. The smaller scale allowed for closer relationships with clients and staff. Every employee underwent extensive background verification before hiring. Trust would be earned gradually through consistent performance and transparency. Evening light reflected off the river as I reviewed the day's case files. The work was challenging but rewarding. Each successful defense of a wrongly accused attorney validated my decision to change practice areas. The legal profession needed advocates who understood both the technical requirements and human dynamics of professional responsibility. The silence in my office was different now. It represented peace rather than suspicion. The constant vigilance that had characterized my final months at the corporate firm had been replaced by confident oversight and clear procedures. It was finally over, and the silence felt earned.